Hello, everyone. Excellent afternoon to you. This is Repower FM. You are welcome to Vision Nigeria on the Repower Network. Now, if you're just joining us for the first time, Vision Nigeria is a program by the Konrad Adenauer Foundation, and it is a German foundation committed to deepening democracy and the rule of law in countries across the world. So it's my absolute pleasure to welcome you this afternoon. My name is Odno Shorena Obozegi. All right, last week on the program, we spoke about the registration of party members, which is definitely an integral part of democracy. That was what we focused on last week on this program. And as always, the views and participations from you were divergent. So for this week, our attention shifts to the 2026 Electoral Act as recently signed by the President Bola Ahmed Tinubu after the passage of the 2022 Electoral Act Amendment Bill by the National Assembly. Now, today, we will be highlighting some of the amended sections of that act and the controversies as well as reactions trailing the same Electoral Act. And just to mention that in the latest act, Electoral Act, which is of 2026, there are several structural changes and reforms, and they border on election funding, party membership, mode of primaries, vis-a-vis choice of candidate, and timelines for nomination of candidates, voter registration as well, the requirement and how to transmit election result, the result transmission. And key or notable of that electoral act, we had the downloadable voter card, which would be that voters can now download their voter cards directly from INEC's website. This will also reduce distribution bottlenecks, lower production costs, and then also improve participation in elections for voters. This is one area of controversy. We also had INEC ruling out under the new Act, Section 84, subsection 2, the procedure for nominating candidate by political parties for elective positions, for example, shall now be by direct primaries or consensus only. Indirect primaries is no longer a thing. As we go on in the course of the program, we would speak more on the areas, and we trust our guest, Jide Ojo, who has joined us now, a public affairs analyst and the CEO, OJA Development Consultant. Good afternoon, Mr. Ojo. Hello, Mr. Ojo. Good afternoon. Yes, I can hear you now.
Yeah, good afternoon.
All right. It's very good to have you join us on the program. And just to mention to our listener, we are live on YouTube. If you prefer to do video, we are live on YouTube at Repa FM Abuja. So you could join us too. Mr. Ojo, let me get your immediate reaction to the controversies that we know surrounded the Electoral Act 2026.
There are a number of controversies, and it is not unusual to have these controversies. Virtually every electoral act we have had since 2001 has been immersed in one controversy or the other. You will recall that the first electoral act we had in this fourth republic that started in 1999 was in the 2001 electoral act, which is why there was another electoral act in 2002 because of the defect of the one that was passed in 2001. So there was 2002, there was 2006, there was 2010, there was 2010 amended in 2015, then there was 2022, now we have 2026. So, if you recall the 2022 amendment, which was quite comprehensive, everybody nodded it. There was immediate attempt by the National Assembly to amend it to now make those of them who are lawmakers statutory delegates who should have a voting right. Of course, President Buhari did not sign that into law. But the 2026 one, the notable drawback attacks that people have pointed to has to do with the issue of e-transmission of results, which the school of thought believe that should not have any proviso. It should just have been there that it is mandatory. And then there is also the angle of why did you have to remove indirect primary and foist only direct and consensus arrangement on the parties, and a host of others. And there was also the initial plan that attempt to criminalize vote buying during the party primaries. That was removed from the bill. There was also the initial attempt to say that if you submit forged credentials to contest election, it should be a grant to challenge your electoral victory. They also removed that. So quite a number of controversy actually attended the amendment or the new electoral bill. But as we have known, there is no perfect law anywhere. The big elephant has always been implementation, or what we call enforcement. We thought we had the Iron Cast Electoral Act in 2022 from the civil society point of view, that this is the best law, this will give us credible election, this one, that one. But by the time cases start getting to court, we start seeing all manner of interpretation of some of these laudable provision. Let me give you a very good instance.
Okay.
We are taught that INEC was going to exercise its power granted by Section 65 of the Electoral Act 2022, which gave it the power to review the outcome of election if there is an issue with what the returning officer has declared. But it was not until recently, last year anyway, that INEC decided to come up with regulations on how to implement that Section 65. They didn't do that. They didn't deem it fit to do that ahead of 2023 election, and only came up to do that. So there were other issues that the court interpreted the issues around whether what is it called? The IRF should have been mentioned in the law or not. This is the same IRF INEC has been using since 2021, which is piloted in National State Constituency election. So you now expect everything to be spelled out in the law. But even now that we have it spelled out, how will the court interpret some of this law at the end of the day? So it has always been topsy-turvy when it comes to electoral laws.
Okay, thank you for that intervention. So let me know what's your position on the act as regards the backdrop of the consensus arrangements that recently we saw it culminating in the recently concluded national conventions of both the APC and the PDP.
Well, I know possibly you don't read me in the Punch. Last week, I think I weighed in on that in my column in the Punch, which I criticized heavily on the application of that consensus arrangement. Because when you look at the textbook definition of consensus, that means everybody agreed.
Right.
But in the real sense of it, these were forced consensus. And I expressed my fear that in the nomination exercise ahead of 2027, we will have a lot of imposition of candidates under the guise of consensus. That's the biggest fear I have. And now, if you look at, I think it's Section 84 of the Electoral Act that speaks to issue of nomination of candidates, and it says you can do consensus, you can do direct primaries. And it says, part of what it's in that section of the law says is that when in a consensus you are not supposed to preclude other aspirants from aspiring to that position. Are you with me?
Yes.
I mean, giving you what the electoral says, even though this is consensus in the opinion of the political parties, which is a bit different from when you apply consensus to general elections nomination. But when you look at the way the framers of our electoral acts put consensus, they say that in applying consensus, assuming national chair North Central. Now, in North Central region, you have 6 states and FCT. 6 states and FCT. But do you know that they didn't just zone, they also microzone to Plateau State. They didn't just microzone to Plateau State, they also chose Professor Natawe Yiwada. So that is no longer a kind of, something that gives room for competition. What I thought should have happened is that, okay, you have zoned it to us, we will vote at the zonal level. Whoever wins this contest at the zonal level gets to come to Abuja for affirmation. But what we saw is zoning, microzoning, and then picking of somebody that is preferred as the adopted candidate. And that is tantamount to an imposition in my own view. And it is the same method that PDP also adopted. In fact, if not for the raging crisis in ADC, ADC has also similarly said they are going to adopt consensus option. So why are they all afraid of having, because the party primaries, the the electoral act did not prescribe for party primaries that they have to do either consensus or direct. They could have done their delegate system because if you look at it, they still have a delegate that came from all the states. For APC, there were 8,354 delegates that still came to Abuja to do the affirmation. In the case of PDP, they still have about 3,000 delegates that came to Abuja. So what is indirect? Indirect is the delegate system. So if you still have to do delegate system, why don't you just allow people, even if it's at the zonal level, to decide whether they want to adopt one person or they want to have it slugged out among aspirants from that zone, in which case it now gives some legitimacy to whoever emerge as national officers. But it is what it is for all the parties. They decided to take the easy way out. But what I'm afraid of is that in the lead up to 2027, by the end of this month, from April 23 to May 30th, when parties are going to be having their primaries, you may likely think 90% of them adopting consensus option, which will be greatly abused, in which case you will see them screening out anybody that wants to stand against their adopted candidate. And that is tantamount to a Baba Sokwe or, anointed candidates.
Okay. Thank you so much for that. That you ended with Baba Sokwe. We'll remember that conversation. But another thing that besides this issue of direct primaries and consensus, people have argued that it's either you are bought or you are twisted to surrender your aspiration in the name of consensus, which is something that you also spoke to. But let's look at another section of the amendments. That's the downloadable voter cards that will reduce, as they say, the distribution bottlenecks. It will lower production costs and also improve participation in elections for voters. This is another area. So we look at Section 16, subsection 1 and section 18, subsection 3, for example, that empowers the INEC to issue PVCs to Nigerians. Doesn't that section of the amendment negate the office of the Independent National Electoral Commission?
Exactly my own thoughts too. You are saying you want to do downloadable, but you also said that what is applicable or what will be issued is permanent PC. This was expressly mentioned as a means of accreditation. So if you download, of course, if it so happens that the downloadable format can also be scanned by the beavers, maybe that will solve the problem in a sense. And I'm still very unclear about what INEC is proposing with this whole revalidation registration that they claim they will do ahead of 2027. Maybe this revalidation will give everybody opportunities to know exactly whether we are going to get a new permanent voters card, or we are still going to use the one we have. Whatever it is, I have not really understood what INEC intends to do. But I agree with you, there may be some confusion in the two sections that you have read out as to how useful, how acceptable with the downloadable card, how acceptable will it be? Because I know that even right now, most of us who have our NIN, national identification number, we only have the temporary NIN, and they said the most important thing is that you have a NIN number, which is the number. It's not the glassy lamination that makes it valid. So I think INEC will have to speak to that at some point.
All right. Well, I think the revalidation has been suspended, yeah?
I don't know. I've not heard anything to that effect because as of last Friday when INEC chairman spoke one of the media channels, he was still trying to explain what they intend to do, that the previous administration wanted to do it, but they didn't have it in the budget. Now they have it in the budget. They plan to have a stakeholders meeting and all of that. If they have suspended it, maybe it's good for the commission so that they can preserve their energy and direct it towards planning the 2027 election better.
All right, we'll check further on that. I think they suspended it earlier this week. But at the national convention of the APC, which just held some weeks ago, the president was speaking about the opposition's position as regards the Electoral Act. And one of the things that he said was, well, while we welcome criticism, the constant attacks by opposition groups on the Electoral Act 2026 are a disservice to the Nigerian people. He added that it is public knowledge that the process leading to the amendment of the 2022 electoral law passed through the crucible of legislative scrutiny, including public hearing. The Electoral Act was passed by overwhelming majority of members of the National Assembly elected by the Nigerian people in accordance with the 1999 Constitution as amended. Then he says, the act reflects our collective quest as a nation to strengthen our electoral system and consolidate democratic rule. Mr. Ojo, do you think that this was indeed the case? Do the people feel represented enough in this Electoral Act 2026?
Well, the argument is neither here nor there. I think I weighed in on that too when I wrote on it last Wednesday in my column in the Punch, where I took excerpt of what the president said and scrutinized some of them. You see, no law will satisfy every segment of the society. No matter how well intended that law is, there will be those who have issues with it, there will be those who have not it. Look at the tax law that this administration is currently implementing. It generated a lot of furore last year. While some experts say it's the best thing after the birth of Christ to have come, because this is overhauling our tax laws that are archaic, that are obsolete, that are anachronistic. So, but many of us have reservation about these new tax laws and the implementation. So, I just gave that as an analogy. So, there will be no law that will have 100% acceptance. But to the extent that yes, it is a representative of the people that passed this legislation, the president was on point on that score, and whether the opposition should have engaged the process more proactively to challenge some of the what you consider draconian and all of that. Maybe it's a missed opportunity for them, because at the level of civil society they engage. The representatives of civil society in some of the retreats, public hearings that were held and all of that. And I have advised, whether you belong to civil society or you belong to opposition party, the court is there for you to ventilate your views. I've given on several media platforms the example of what happened to 2006 Electoral Act. That act, I think it was Section 91 of the Electoral Act 2006, which gave, as at that time, in that 2006 Act, there was public funding for political parties. So that Section 91 now says public funding will be shared at the ratio of 90% for parties that have representation in the National Assembly, and only 10% will be shared on a prorated manner for all the registered parties at that time. And the Congress of Nigerian Political Parties at that time, which was who was Barrister Max Eoku as his national secretary, took the INEC and the National Assembly to court. And Justice Ademola Ogie of the Federal High Court gave judgment in December 2006 that look, This is contradictory to the provision of Section 228 sub C of the 1999 Constitution as amended, and it was struck out. That section of the Electoral Act was struck out. You understand? So the court has power to invalidate certain controversial sections of the Act. Yeah, and it's not just electoral act, any act for that matter. If the court is persuaded that it is ultra-vires and against the letter and spirit of the Constitution, and that I remember very vividly, I've canvassed that operation, because it is also possible that as at the time National Assembly was doing their own bit and inserting some of these unpopular sections that we have discussed, maybe if the opposition have run to court, the court will say, why do you have to come at this point when the process is still inchoate, which has not been consummated? Now the process has been consummated, they have decided not to revisit the electoral 2026, perhaps until next election is over, and now what we are forced with fait accompli. The only saving grace for the opposition and the civil society who disagree with any section of the law is to go to court. And if they are able to ventilate their argument in good time, maybe the court can still give them favorable judgment that will be bound on INEC to obey. But we need to also highlight the fact that time constraint is very, very real. As I speak with you now, by April 23, party primaries are supposed to happen. From April 23 to May 30th, INEC already has agreed to the fairness or to the advocacy of the IPAC in terms of what timeline they should submit their digital membership register and print copy of their members as initiated in section 77 subsection 2 through to subsection 7, that if they fail to submit this digital membership register according to section 77 subsection 7, they will not be allowed to participate in the electoral process. So because of the time constraints, the IPAC had advocated to INEC that they should be given more time to do their membership revalidation and registration, particularly in section 77 subsection 2, and asked that you have to submit your name, you have to submit your so many details about yourself, including your photograph, so which many of them don't have in their registers as now, which is why all the parties are doing revalidation. Now, INEC has come down to meet them, give them an extension of almost 2 weeks to tidy up this by saying that they now can submit by May 10. Rather than in April, they can now submit their digital membership register by May 10. But to now go to court can still come to the aid of the IPAC or opposition party or civil society who have issues with this electoral act. But we have to have at the back of our mind that time constraints may actually have robbed us of that opportunity.
Mr. Ojo, right. I think that's one other area that we can look at, which is essential, is the election campaign spending limit. Before now, we have for the presidency was limited to spending 5 billion naira for campaign, but now that has been doubled. It is now 10 billion naira. Governorship, it used to be 1 billion naira, now triple 3 billion naira. For senator, it used to be 100 million naira. It is now 500% higher. That is 500 million naira. House of Reps, it used to be 70 million naira, now 250 million naira. State House of Assembly, it used to be 30 million naira max. Now it has been raised to 100 million naira. We also have area council chairmanship from 30 million naira max. It's been raised to 100 million naira. And then councillorship is there as well for 5 million naira. It's now raised to 10 million naira as well. And for personal donations, it used to be 50 million naira the max, but he's jumped up to 500 million naira. Mr. Ojo, at a time that the Central Bank of Nigeria is warning against excessive election funding of campaign, at the various election and elective positions that I've reeled out, what is likely the consequence of this spending limit on the economy?
Well, in every election year, there are bound to be inflation because of the money that will be in circulation. So, this whole argument by increasing the spending limits, there are a number of issues with it. One, the ceilings are not being done in a scientific and logical manner. You know why I said that? If you say that, I will come to inflation and how it affects, which may be used to justify the increase. But let's look at the arbitrariness in ascribing figures to all positions. A senator is canvassing for election in 1/3 of the state because there are 3 senators for every state.
Yes.
So you said that a senatorial candidate can spend, you said 500 million.
Yes.
Huh?
Yes.
As a new limit, 500 million.
Yes.
But a governor can spend 3 billion.
Yes.
Why did you say that 500 million times 3? Because there are 3 senatorial districts. So that should have given you 1.5 billion as maximum spending limit. Okay. If a presidential candidate can spend 10 billion from 5 billion, and we know that there are 36 states, you understand, in Nigeria, there should be a scientific basis and benchmarks with which you can logically explain how you come about these increases. That's number one. Number 2 is that in 2002 electoral acts, something was introduced at that time, which was to use the number of voters in a register of every state to determine the expenditure limit for that state. So, the ascribed at that time, is it 10 or 20 naira per voter, multiplied by the number of registered voter in that state to be the spending limit. You know, that seems a bit logical. If you say, so you are not likely going to have every state governorship candidates spending the same limit, because Kano's population is higher than that of Ekiti. That of Ekiti is possibly higher than that of Bayelsa, which has its local government. So, but to not arbitrarily just ascribe figures that are bogus as spending limit is out of it. But the third point that needs to be made is that, is this increase justified? I will say yes. Now look at how much we buy petrol in 2003, during the 2003 elections. We were buying petrol for less than 200 naira per liter, 180, 190, 200 in many places. But today, that same liter of fuel is sold for 5, 6, 7 times what we were buying it 3 years ago. And that affects virtually everything. In 2023, INEC requested for 350 billion in 2022 budget, an additional 150 billion thereabout in 2023 budget. Today, INEC is requesting for close to 1 trillion. 870-something billion in one stretch, 175 billion in another stretch. If you add the two together, it gives you an excess of 1 trillion to run the 2027 elections. The reason being that the unit price of everything that the commission will need has increased exponentially. Whether it decides to even print ballot papers in Nigeria, it is not the same amount that the printers in 2023 got that they will charge in 2027. The same way with virtually every procurement that has to be done. Even the adult staff that were recruited, about 1.4, 1.5 million that were recruited to conduct the 2023 election, they are pay the same allowances as they were paid 3-4 years ago. Because if they paid those core members to 20,000 at that time, the person will have to pay them 50,000 this time around, unless they would. Otherwise, they may not get people to come and to volunteer to come and conduct the election. So the price of everything has increased, given the inflation and the devaluation of the currency. So to that extent, I would say certain increase in the expenditure ceiling is justified.
Okay.
But we also to understand. Let me land on this thought, please. We also need to understand that the fact that the ceiling was set for that amount does not mean that you have to spend it. It's just a ceiling. You can spend far less than that.
Mm-hmm.
If you have good things, you don't. I mean, nobody will mark you and say, "Oh, why didn't you spend up to 10 billion for your presidential campaign?" And the last point I need to make is that, in fact, I've been involved in tracking of campaign finance over the past 2 decades or more, and I know for a fact that this section of the law is observed in breach. It's observed in breach because far higher sums of money are still going to be spent by the candidate with war chest, and there are quite a number of them. I used to think that in 2022, when for instance APC charged 100 million for nomination fee, that they will not get people to buy the form. But we still have close to 50 people who threw their hats in the ring and said they are going to contest. So the point is that it is not mandatory you must spend that ceiling, but for those big spenders, particularly those in the dominant political party, some of their candidates will still spend far higher than that sum of money. So, and the INEC does not at present have the capacity to track the expenditure of the political parties, even though they have the law behind them to do it.
Okay, thank you so much. Just to mention to our listener as well as our viewers who are watching us from YouTube, our phone number to reach us is a participatory, a two-way program. Our phone number to call in is 0916 333 4965. Again, 0916 333 4965. You can call in from now to share your thoughts or ask our guests your questions about our topic. While we await your calls, we'll return to our guest, who is Jide Ojo, Public Affairs Analyst and the CEO, OJA Development Consultant. We've been looking at the Electoral Act 2026. And Mr. Ojo, what do you make of that section of the Act that stops a politician from defecting after the primaries have been commenced? Some arguments say that this is a violation of their rights of association. Do you think same?
The law on defection, I think that was not effected. That was what House of Reps tried to amend the already signed Electoral Act to forbid people from belonging to two political parties. And I don't think they have pursued that to a logical conclusion. But in any event, I think it might be very tricky for anybody to belong to two political parties in this dispensation, given the fact that part of the reason, the mischief that Section 77 in total tried to cure by insisting that you have to now submit in Section 77 sub 2, you have to submit digital register of your members as well as print copy, is that you have to submit the 21 days to your party primaries, and you cannot belong to two political parties at the same time. So, if your name appears in the Labour Party register, it is expected that you cannot be in Labour Party.
Hello, Mr. Ojo. Mr. Ojo, a minute, please. Let's take this call. Hello, good afternoon. Where are you calling from? Your name and your
this is Ahmed calling from the States.
What is your name again? Hello.
My thing is that I want the party member to the party you should respect our law. And the law that this Nigeria belongs to all of us. They should respect Nigeria. Whatever they are doing, first. And again, I want to thank my president, Bola Ahmed Tinubu, for the beautiful work.
Okay, thank you. Thank you for your insight, although it wasn't exactly clear. We have another call. Hello, good afternoon. Where are you calling from? Your name? Hello, good afternoon. You are live. Hello, good afternoon. Oh, we lost connection. All right, Mr. Jide, let's come back to you for you to continue your thoughts on that.
So, like I said, you can't belong to two political parties because in time past, court has ruled that for you to belong to another party, you must formally resign from the previous one and join the new party. And since there is a purpose for which INEC is now to have your digital and print copy of your membership register, you cannot 21 people to your primaries be in the register of one party, and then after the elections, maybe you fail to win the nomination of that party, you now decide to go and defect. There is no, the law does not say that after the nomination, you can now join another party to enable you to perfect your defection to go and contest on that. So it is like a cul-de-sac, as they say in I don't know whether it's French word or English word. Cul-de-sac that once you enter, just stay where you are until the next election, when there will be revision of membership register, and then you can effect your change. But if you now think you can play with the air and hunt with the horns, you may find yourself in legal trouble if you belong to two political parties, because now, unlike what obtains with 2022 Electoral Act, where they just said submit your membership digital register and then without saying that you should submit your name, you should submit your picture, you should submit your ward, local government ward, state, down to your polling unit. All of these details are supposed to be on the register that your party will submit to INEC. And no two individuals will have the same name, even if you have the same features. So I think that has already precluded people from belonging to two political parties, and then that's why you see that this window for you to invalidate your membership of a party or to register afresh with another party is there for you to take if you plan to contest.
All right, sorry, we appear to have a call. Oh, well. Hello, can you hear me?
Hello?
Hi, good afternoon. Please, your name, where you calling from, and your thought. Please excuse us, Mr.
From the state. Thank you.
Okay, thank you so much for calling back. All right, we'll come back to the studio. Mr. Ojo, we had to bring in a listener as well as viewers on YouTube. Another concern is the argument that the provision stopping the court from halting primaries and elections following litigations by aggrieved candidates, and it amounts to Section 6 of the 1999 Constitution on separation of power and an infringement on the fundamental human right of the affected person or groups. We're still talking about human rights and the Act.
Yes, please, what section is that?
Section 6 of the 1999 Constitution.
Yes, what did they say?
that this electoral act, that some are arguing that the provision stopping the court from halting primaries and elections following litigation by aggrieved candidates, it amounts to Section 6 of the 1999 Constitution on separation of power.
To the best of my knowledge, ASPA clauses are undemocratic. You cannot tie the hands of the court and say the court cannot rule on party primaries. But the intent of the framers of our electoral act may be to prevent a frivolous process of stopping the party primaries from being held, knowing full well what they intend to do with the consensus arrangement. It may intimidate quite a lot of people and may make them to seek judicial protection to have those primaries held without them. Don't forget what happened with PDP last year in November when the Makinde faction wanted to go and hold their convention in Ibadan. And former governor of Jigawa State, Sule Lamido, tried to purchase form and was not sold the form. He went to court and the court actually declared that that convention in Ibadan cannot go ahead because it's a breach of his fundamental rights. I don't know whether you remember that case. It's still very fresh. Where the court ruled, it was another court ruling that stopped the Ibadan Convention from holding when the Sule Lamido went to court to challenge that the fact that he was not allowed to buy form is a breach of his fundamental right. And the court agreed. So we may say as at that time the electoral 2026 has not come into effect. But let's see how the court will interpret this, whether it should uphold that section of the electoral act or given the fact that electoral 2026 is inferior legislation to that of the Constitution, whether the court will countenance that provision and uphold, accept to stop party primaries by those who are aggrieved, who may want to stop that process.
All right. Thank you so much. I mean, the Ibadan Convention is still very fresh, as you noted. That was just November of 2025. Public Affairs Analyst and CEO, OJA Development Consultant, Jide Ojo. Thank you.
OJ Development Consult.
Oh, okay, consult. Thank you. Thank you so much for your time on Vision Nigeria this afternoon. It's an absolute pleasure. Thank you for your rich insight, as always.
Enjoy your afternoon. Thanks so much for having me.
You too. All right, everyone. We'd like to thank you, our dear listeners, as well as our viewers on YouTube, for staying with us today on Vision Nigeria. And we'd like to thank our beloved sponsor, Conrad Adenwa, for making this possible, and to the crew, the executive producer, Gbenga Arileba, producer Fumi Emokbai, studio manager Yakubu Zaka, and Isa Elams. We also have our social media manager, Adede Blessing, and me, your presenter for today. I am Onosho Rena Obozege, Rena OBO, on the space of social media. Until next week, do have yourself a good week. Bye for now.
Providing 360 degrees of information and entertainment. Reloaded for today's Niger.
Ray Power.
Ray Power.
Ray Power. Ray Power.
Nigeria's original independent radio station.